I want to thank everyone for attending this session. We've had a couple of good illuminating sessions in the morning, and I think now we're going to try and get into the brass tacks. And M&A is one area which I know there's obviously a lot of interest in India. So we're going to just probably deal with the M&A landscape. And the good thing about this panel is that it's a good balance. So you've got practicing lawyers predominantly specializing in M&A. You've also got in-house counsel who, this is their focus. And we're going to touch on a number of areas which I think are very topical, particularly in this context in how we're dealing with M&A transactions today. And in that discussion, we're going to try and deal with some of the more thorny issues that have arisen recently. But the first one that I want to try and touch on is a very broad and sometimes misunderstood topic, and that's ESG. And what role does it have to play in M&A transactions? Typically, people aren't really that sure. We all sort of have our own views. Could be something dealing with compliance, but there's a broad framework around ESG that is still quite nascent in a market like India because it's not as regulated. So let's start with that. It's the topic du jour. So maybe if I could press Prasenjit to just explain to us what is the relevance of ESG in the context of M&A transactions today?
Sure, Ashish. Firstly, good afternoon to you and my esteemed panelists and all the audience members here. Very good afternoon to you. So first question is, is ESG relevant in Indian M&A context? The answer is absolutely yes. And I will make good this point from my live examples from the deals I'm doing currently, how it is important and how we should focus on it. I think firstly, it's very important for any investor that the reputation of the company which it is investing is sacrosanct. And let's take an example without naming. Let's say there's a company whose environmental policies are not very robust, and an incident is looming large and a fire breaks out. There are loss of employees' lives. What happens besides the huge cost? There is also a reputational damage, and no investor in right mind will like to touch that company. We also very well know what happened to a very well-known automotive company who tinkered with the diesel emission norms, and what happened thereafter, that the reputation tanked big time. So these are not trivial matters. All of this means that if you can preserve your reputation, mitigate against any potential loss to that, you can definitely help your case as far as inviting investors to look at your company more seriously. That's one part of it. Second is every investor nowadays is with a close focus and attention examining companies from a ESG scorecard standpoint. So how well does a company fare? Every investor, I'm sure my fellow panelists will touch upon it from investors' perspective. And if you perform and fare poorly, that's an area of concern. And therefore, again, it's critical that you take a look. Because ultimately, if you fare well from a valuation standpoint, investors will pay you the value which you desire for, and that's ultimately one of the key objectives of M&A deal, the right valuation. The third important facet is that even customers are increasingly looking to be associated with companies who have a sustainable growth model, not people who are just out to get some short-term profits in a way to kind of drive up their valuation, but resorting to all kind of nefarious means. That really is not something you should continue if you're a company. You should up your game. The fourth standpoint is from a buyer standpoint. A lot of time has to be budgeted for ESG due diligence. Now, what does that mean? Because when you negotiate a term sheet, you will obviously have an exclusivity period of 60 days, 90 days to do your standard diligence and negotiation of definitive agreements. But you must budget for 30 more days or 40 more days for a ESG specific diligence, because this is not ordinary diligence. It has to be a very customized approach has to be adopted. So that's the fourth point I will make on this point. The fifth and the penalty point is that many times people have a misapprehension that ESG is only applicable to listed entities because SEBI has come up with the BRSR norms, so on and so forth. Nothing can be farther from the truth. Obviously, listed companies understandably have the top 1,000 companies with market capitalization to comply with this exhaustive report. But you have ESG laws scattered across plethora of laws. For example, corporate social responsibility norms under Companies Act. Similarly, other laws which are applicable, labor laws. Now, you should definitely comply, which is mandatorily applicable, but even voluntarily, if you do step up your game and comply, that will again enhance your reputation, efficiency, and desirability before the investors. And the last point is, even for an employee standpoint, employees also, top talent wants to stick around and join organizations which have a very pro-employee policy. We have seen a lot of negative news in media where people have been recklessly let go of. Very poor management, I would say, of people. That again, does it help your reputation or not? I think that we all know the answer. So those are the 6 points, because that's why ESG is so important. And I have seen at least 2 transactions in last 1.5 years got tanked, aborted at a diligence stage because there were ESG issues, oil spillage issues on the ground, greenwashing issues, which basically is eyewash, right? Greenwashing means we all know basically tall claims are made by the company, we are ESG compliant. When you look closely, it's all hogwash. So all these points makes ESG a vital component in M&A transactions in Indian context and not to be overlooked. Thank you.
Thanks, Prasenjit. So I think the E and the S within ESG are things that people talk about quite significantly. And I think there is a certain degree of value in that. But sometimes the lesser known G component, the governance component, plays a very important role. And most people tend to not see it in that perspective always when you're looking at it in the context of M&A transactions. So, Natasha, going back to the G component, you've got covenants and representations, for example, of anti-bribery, corruption obligations. How does that play a part in M&A transactions from your perspective?
Okay, let me take this one. Thanks, Ashish. So I completely agree with Prasenjit and that, ESG is extremely important from a buyer's perspective. And if you're looking at current trends and outlook, this ESG is probably the most sort of hottest trend in M&A transactions these days. But look at it from a seller's perspective. And I've got this from clients when I have been representing sellers in an M&A transaction. In the Indian sub-context, everybody in this room, and I can talk freely, this is just my view, in the Indian sub-context, we know how business is run. We know that when you are putting in anti-corruption, anti-bribery, first of all, we put in these definitions, especially if there's some foreign direct investment or indirect foreign investment, we put in the corruption laws of not just India, you will put in the FCPA, you will put in US laws, UK laws, then you will put in reps from the seller saying that they are in full compliance, including all their group companies. I'm telling you something that I've seen recently. All their group companies are in compliance with anti-corruption laws. Now, this is US law, Indian law, etc. Now, as a seller's counsel, my client calls me, and this has happened many times, and says, how can I give this? I can't give this. I'm in the for example, I'm in the pharmaceutical industry. I cannot give a rep saying that I'm in complete compliance. I think you guys know what I'm saying, right? Everybody in this room sort of knows what I'm trying to say. And it's something that I feel strongly about because I don't like to tell my client that, well, you have to give it. There is no option, because what I'm basically saying is you're giving a misrep from day one. But I don't think there's an option, because buyers insist on a complete rep with no materiality and no qualifiers. We are told either accept it or don't, but that's it. And in fact, they want to include group companies as well, which are not even possibly being sold. So I think sometimes, there needs to be a sort of balance. People who are coming into India maybe need to understand the sort of how businesses do function. It's easy to just sort of push it under the blanket, but everybody knows the truth. And perhaps it's time to also kind of look at it a little bit from, I'm not saying don't do an ESG diligence. Of course, do it. But when it comes to certain practical aspects of doing business in India, maybe it's something that buyers should be a little more aware of in terms of asking for such reps.
Thank you, Natasha. From ESG, let's go somewhere a bit broader, and let's look at just regulatory issues. Now, when you're looking at regulatory approvals, that can be a very challenging process, particularly in India. We all know NCLT, there are different other regulatory bodies. We'll discuss a few of those. But before we get there, let's get some perspective from Vardhan about regulatory challenges that buyers face, in particular when you have timelines which are quite aggressive, and let's say you're trying to invest overseas, or if there's issues with foreign investment, sensitive technology. What's been your experience, Vardhan, in dealing with these sort of issues?
Thanks, Ashish. So, we are amongst lawyers and, people who are usually conversant with how M&As happen. So I think I'll focus on the offshore piece more than the, onshore. Of course, in India, just to briefly touch upon it, I think, regulators who kind of keep me awake, not for any other reason, but because that there are so many compliances, right, that you need to be on top of to get a deal done. Now, and that kind of changes with sectors, with the stage of the company, etc. So it could be CCI if I'm doing a big M&A and, just getting information from the target, yours, kind of considering where are the overlaps, what are the possible overlaps, and then kind of taking, consulting with business to project it, to understand how that market needs to be sliced and diced to make the regulator understand many times as to what sector we are talking about, right? Fintech, for instance, is such a huge sector, but it may not always be the case that, if you get deep into fintech, maybe insurtech possibly also is a part of it, but may not necessarily have an overlap with lending. And to make the regulator explain that is one thing that, we kind of spend a lot of time on. What we also feel, and I think that is the more important piece on the buy side when we are looking outside, this one thing that I noted that, as Indian lawyers, because we are so domestically driven and most of our deals are Indian buyer, Indian seller, or a foreign entity investing into India, we are usually always dealing with the Indian legal ecosystem. We are not usually interacting with, let's say, Italy or, on many deals, let's say 80% of the deals. It becomes very challenging to manage that process because, like India, if you get into a multinational purchase transaction, you would find that there are so many other laws which you may not otherwise even have an instinct of may get triggered. Now, one thing that I kind of regularly deal with is in the US is sensitive technology. So they have something called the CFIUS, which is a regulatory body which looks at acquisition of companies in the States by anybody outside the States, and the subject matter of that company should not be something that the US believes impacts the national interests or security of United States. And interestingly, the list that they refer to is not a separate list that the CFIUS publishes, but the exporters list and the importers list that the which a separate department publishes. So there are, and it kind of functions like an antitrust authority with draconian powers, like, let's say, reversing a full transaction after you've invested. So, dealing with those kind of things, explaining it to business, internalizing that risk, if at all, is where, and it definitely has an impact on timelines, right? You're dealing with CCI on one end, CFIUS on the other, and maybe an Italian FDI as a third one, and you've got something in Japan as well. And that is where it becomes extremely challenging to put everything together, I think. It's just about pure play project management more than anything, but also having a keen eye for where else can there be issues. Because many times, sorry, this is a kind of long-winded answer, people will give you reps, but reps are really not anything to me. It's really whether there is a risk or not. Somebody may give me a rep, I may acquire, and tomorrow CFIUS slaps me with a fine of $1 million or hundreds of $1 million, I don't know. And that's what is the mitigation that you need to keep a lookout for.
Thanks, Vardhan. I should have mentioned in the beginning, we are planning to allocate about 5-10 minutes at the end for Q&A. But feel free, if there are questions that you think are relevant or you just think this is a good opportunity to ask a question based on what we're discussing, feel free to ask. We will certainly try to get to as many questions as we can. The idea is to make it as interactive. We've got something to just try and, at least jog everyone's energy and try and see if there's something that does warrant some, other thoughts that you may have based on your experience. But we're very happy to hear from you. But I think that, Vardhan's point, I think is quite helpful and helps us to then try and contrast that with the position in India. Because even if you're doing a deal in India, you still have a significant number of regulatory challenges. So Natasha, maybe just based on your experience, could you just sort of set out what are some of the key regulatory challenges that you see from the Indian context?
Sure, Ashish. So I'm going to get into a little bit more of the nitty-gritty compared to Vardhan. But I think the main sort of 2-3 things that we usually see in M&A transactions. The first is, as Vardhan said, the CCI, the Competition Commission approval. If you might be aware that there are amendments that came into place in April. Some of them are yet not in force. When you are doing an M&A transaction, you may need Competition Commission approval if you exceed a certain threshold of the net worth of the company or assets of the company. So most of the time, hopefully, you sort of get out within those exemptions of the threshold, which is what we all hope for, so we don't have to go for the approval, whether you're buyer or seller. But what's happened in the amendment is that now not only is there a threshold for the net worth and the assets of the target, but the amendments now also look at the transaction value. So now, if your transaction is over 2,000 crores, which is 20 billion rupees, you will have to go to the regulator for approval. And there is an and, that your target has substantial business operations in India. And this is how the amendment stands right now. It might still get amended further because it's still not in force. But what is substantial operations in India? That's something that's so subjective. I mean, there are other jurisdictions which actually sort of have a measure of what it is to make it more objective, whether it's, the market share of that entity, the, geographies in which it operates. So it makes it more objective and instead of subjective. So we're still hoping for those amendments to come in for this sort of the CCI approval. The other thing is, when you talk about 2,000 crores, a lot of M&A transactions have deferred payments, earnouts. How will that work? How do we measure the 2,000? Do we, is the earnout part of that 2,000? Is it not? So, again, gray areas which always sort of tend to, delay transactions. People are not sure how to move forward. So CCI approval is one thing which is really sometimes, sort of, I wouldn't say a roadblock, but definitely something to consider in transactions. The other thing is the Press Note 3 of 2020 issue, which we saw during COVID, which was approvals required from the RBI if you were getting investment from a country that shares borders with India, which mainly was China. Now, I have actually had clients who called and asked me that, the beneficial owner, because that's the key, is in Hong Kong. Is Hong Kong sharing borders, because now obviously Hong Kong is part of China, but is it really part of China? And, we had to take a call that, yes, they would probably, RBI will see it as that, and therefore they just sort of didn't go ahead with the transaction because those approvals were taking close to 6 months to a year. And I was just, while researching for this, found out that since 2020, out of, say, 490 applications, RBI only cleared about 98. So just, this issue is huge because your significant beneficial ownership, which is 10% in one, that's another gray area, 10% versus 25%. But if you have some guy sitting right at the top, whether it's an entity or otherwise, in China, in Hong Kong, which is very possible. So you're now subject to regulatory approval. So that's another sort of issue that comes up in M&A transactions. And another interesting thing that's been happening is compliances and disclosures. Regulators have, gone, pushed, put their foot on the pedal. SEBI has been coming out with all sorts of regulatory requirements. And while those are all great, when you are, again, it goes to your reps. It's so easy then to trip up on a rep. For example, I was reading this, it's actually funny. SEBI now expects you to disclose all penalties that are levied on a company, and there's no threshold. So I believe that Sapphire Foods, which is, Yum Foods, runs KFC and all these other brands, they were penalized for 10,000 rupees because there was no trash can in one of the KFC outlets. And they actually had to make a disclosure because, that was their disclosure, they had to make it on the exchange website. I mean, these kind of things need to, and we're all for corporate governance. But I think at some point there has to be a yardstick, a sort of threshold value, a measure. It can't just be completely, sort of off the cuff. And the last one, and again, I like to talk from more a practical aspect, and this is something I have faced in the last 6 months, and that is our ROC website. I don't know if any of you have had this issue. My clients have not been able to move forward in a transaction because I couldn't file my PAS 3, or if I was doing debt PAS 4, whatever. But the point is I couldn't do it, and without filing those forms, incidentally, you can't use the fund. So if there's a fresh primary issuance, you can't use the money. So everybody is on board. Money's come in to the country from whatever investor, but they couldn't use the funds. They were just stuck. And then the ROC came out with some circular, but that didn't work. We said, let me do it physically. We went, sent people. How is that ease of doing business? I can understand that it was being upgraded in January. This issue was still a problem even as late as June, at least the last one I did, end of June. It's still a problem. And for somebody, a country who is so tech savvy, and most of our guys are doing all the tech work in India, I can't understand why our ROC website still has this problem.
Okay, that is obviously one of the challenges that all of us have to face. Moving from there, I think another interesting area is the IPO market. And at least recently it has slowed down. And I think the issue really is that post-listing, you'll find that there have been issues with respect to the financial performance of the issuers, and the value of these IPOs has gone down. So Kaushik, based on your experience, how important is profitability for financial investors, PE investors who are looking to exit IPOs?
So thanks, Ashish. Thanks for that. So I guess I'll start off by saying that an exit is an extremely important part of every financial investor's investment in a company. It starts getting planned on the day you make the investment. It is covered in the investment agreements. And I guess the most popular, or the way to exit with the highest amount of profits for the investor is an IPO exit, usually. Clearly, because the public markets generally fetch you a better price than doing a private deal and exiting with somebody else coming in either strategically or from the financial markets itself as a financial investor. So what started happening? So in 2021, for instance, there was about 280 exits there were. And out of that, I think total amount of 43 billion was sort of recovered by the investors through these exits. But what started happening, and what was quite evident, was a lot of these companies, in fact, some of them immediately on the day of listing, started losing value, and after the anchor investors, which is in a month's time, got out, there was further loss of value and erosion of value, simply because these companies, I wouldn't say simply because there's a whole host of reasons that may be attributed, and nobody really knows, right, why a stock is losing value. It just is. So, but the one common thread amongst all of this was that they were all loss-making companies. So, SEBI has a rule which says that even if you don't have that profitability track record, you can still access the IPO markets if 75% of the issue is subscribed to by qualified institutional buyers, which are essentially sophisticated investors. So even if the company doesn't have that profitability track record, if so many investors and sophisticated investors have faith in your company, you can still exit. But of course, what we started seeing is that share price was tanking and all of these stocks were losing value. So SEBI came up a while back, actually not too long ago, came up with a proposition that the investors could not completely sell out and exit the company in an offer for sale, which is a secondary exit in an IPO. So what the rule now says is that, if you're over 20%, then you can only sell up to 50% of your holding. If you're less than 20, then your pre-issue holding of 10%, you can't go beyond that. So what it does is it ensures that the investor has a certain amount of skin in the game, even post the IPO. It's not just a one-time thing that they sell out at a valuation because the stock has no value, and it's an estimate based on certain rules that you come up with the valuation of that company. But what it does is that it ensures that even post listing there is some skin in the game for these investors. Now, I would think that that there's two schools of thought to this. One is that if you've actually made a rule which says that 75% of sophisticated investors are coming into your issuance and therefore profitability is not the parameter, then you need to stick by it. Why are you thwarting the exit of investors who've come in, who've spent time with the company, built it up, and is now wanting to exit? Of course, the other school of thought is that, that's what SEBI is trying to do, is protect the public, right? I mean, there is also 25% of public coming into the company, other than these 75% sophisticated investors. Now, when the share price tanks, it is obvious that some of these public investors are also losing value. So I think it's a protectionist sort of a move. I think that perhaps some will say that it's over-regulation, and it is actually thwarting investment into India. But I think it's open for the group here to decide. But it was certainly necessary from SEBI's perspective. It has managed to kill part of the PEVC market in terms of planning their exit, but that's where we are.
Thanks, Kaushik. Apart from profitability, Vardhan, if you could quickly tell us what other concerns are there for PE investors who are looking to take a company public?
So, first is that, at least this is my impression, my opinion. I feel that no PE investor has made a lot of money taking a company public, right? Because public markets is not where you make money. The ideal outcome for me would be I invest in a company and then a strategic investor, a listed strategic investor or a strategic investor, huge conglomerate comes and buys my company because they see a vertical or a horizontal fitment into their business. And that's where you get real values which get unlocked. So, because those guys will pay you for what you've actually done and for what they see in the business, and those are the people that you can discuss a DCF or a market comparables kind of a benchmark to value the company. Retail investors usually don't understand that, and even I don't understand when I am investing. That's why I stick to mutual funds. But apart from profitability, when you are taking a company public, one thing definitely is that it's a feather in the cap of the private equity or a buyer or an investor, is that I have taken X number of companies public, meaning that when I come into a company, I'm able to hold the hand of the management and the promoter and take them to the next level of governance, etc., and take them across. So that's the background with which you kind of come in. I think the things that keep us awake is whether I will be a promoter, because SEBI these days is taking very interesting views, and Kaushik would kind of agree. SEBI thinks that if I own 25% in a company, I am hands down promoter of the company. We all know at 25% we don't exercise, unless it's a very diffused cap table, we don't exercise a lot of control in the company in terms of operations at least. And promoter by definition, if you look at Companies Act and all other statutes, is somebody who exercises operative control and manages the affairs of the company. So that is one thing that we kind of look at. Similarly, I think Kaushik extensively covered the lock-in considerations, etc. So I would say that, there also the regulator needs to take a view. Are we going to let the securities market history develop and let the market then price assets appropriately over a period of time? Or are we going to be not knee-jerk but slightly protectionist and, wherever I see a little bit of a slip, intervene and immediately kind of go to the other extreme? For instance, the related party norms that have come in now over the past, I think 18 months. I think if you're 20% owner in a company, you are a related party. Imagine if you're a financial investor. And the implication of that is I can't vote on a matter because I will be taken to be a related party and basically in collusion with the promoter, which I think is kind of counterintuitive. You're actually not letting a financial investor bring in corporate governance. So I think that kind of finesse and nuance in regulation, needs to kind of develop, and we need to be a little more, the regulator needs to be a little more forgiving, and the market also needs to perhaps be slightly more conscious. That's where I'd put it.
Thanks, Vardhan. So we are running short of time, but it would be remiss of me not to deal with one broad topic, and that is risks. What are the specific types of risks that need to be addressed and dealt with, particularly in the context of M&A transactions in India? And maybe if I could then get Prasenjit to try and give you, just if you could tell us some of the basic key risks, and then Kaushik, if you would like to supplement after that, just a few risks based on your experience that clearly are risks that need to be dealt with head on.
Sure, Ashish. I am taking my phone out not to check my emails, but the time, because I think Ashish has warned it's time to close. So I think it's obviously, I think anybody who is familiar with M&A deals knows that how buyer insulates and protects deal. That's the, really why M&A lawyers like me, Natasha, etc. come to the forefront. And what are the kind of risks? I think firstly, very quickly, when you really at a very outset do a term sheet, as a buyer, the biggest concern we have is will the seller sign a term sheet and shop around with that term sheet, get a better valuation and bid goodbye. And therefore you must have an ironclad exclusivity stroke no shop agreement, which should kind of insulate you from any kind of this kind of activity. Second is, of course, confidentiality. That's an additional tool so that the seller doesn't again talk about that deal, etc. It's kind of hush hush till the time things fructify more. So that's the term sheet stage. And of course, to give teeth to all that, you need a break fee. I mean, no point in just having a covenant saying that, look, well, there's a no shop. Now, let's say I'm a seller, I breach it. So what next? Will you go and sue me? Good luck with that. Nobody's going to give you damages. What loss have I suffered? You must have a break fee to quantify. Of course, we can debate offline how much is enforceable in India, how much I've seen, not seen. That's a private conversation because I can't divulge names. Second kind of risk is counterparty risk. So let's say we have a counterparty again. Somebody was mentioning that we can have all the reps and warranties and indemnities on the planet, make it a great agreement. But what if the seller has no financial wherewithal to pay? What will I do with the warranties? Therefore, the counterparty risk assessment is often ignored. People are so exuberant that they have a M&A deal on the table. They like to believe the counterparty more than the spouse because at that stage they want to do the deal. So when you as a lawyer tell them, look, hang on, you have what is the check record, track record? Will the seller honor the obligations? Not. All that is scattered to the wind. So you must do a counterparty risk. And if there is an element, an iota of doubt about counterparty credibility, then you must have arrangements like warranty and indemnity insurance, which is again seeing a lot of traction increasingly, or have escrows, holdback, deferred consideration kind of model. But not something to be trivialized. Counterparty risk assessment is a sensitive issue, but has to be done. The third bucket of risk assessment is between when you sign the contract and closing. There you must ensure as a buyer that a company runs in the ordinary course, and there are again stringent kind of interim governance in place. If it's a locked box deal, which is great for the seller because the value gets frozen, the box is locked. Even more important, that a buyer then has a very good tight leash and control over how the business is run between the signing when the valuation is frozen and until closing. That's a third point. The fourth bucket of risk is, of course, is the reps warranties, indemnities, whatever your diligence throws out, you capture that, tailor that, customize that. I think Natasha was alluding to mindless reps, whether a particular business is really not relevant to a warranty for a particular business, you still ask for it. It's very important as a lawyer to customize your reps. Of course, you can throw the kitchen sink. Nobody's saying don't do that, but also customize your indemnities where the shoe pinches. Have specific carve-outs, have holdbacks if there's an issue. Don't just say, okay, I've got great 100% indemnity, but again, what the seller can't pay. You're not in the business of suing the seller, right? So therefore, that's very important to keep that in mind. Lastly, once the deal is done, what about your non-compete? What if the seller sets up his own shop and again surreptitiously continues to run the business? And of course, you must have ironclad non-compete, non-solicitation clauses. Very important. And of course, let me also tell you, there's a common myth that non-compete post-termination doesn't work. That only doesn't work for employees. In an M&A deal where goodwill is being transferred, it does work. There are Katinov judgments on that. So you must have a non-compete clause which restricts the seller from competing the business. If you do all of this, take care of some of the regulatory hurdles as CP, CCI approval. My colleagues have talked about it, because you don't want a regulatory approval coming back to bite you in the back tomorrow. So you must identify them and redress them and allocate the risk. See, M&A is not a dead deal where you take the money at the interest. It's a risk allocation debate. So CCI approval, let's say it takes 6 months to come through. Whose fault is it? It's not nobody's fault. But you have to carefully negotiate your termination rights. It can't go on forever. So you must have outer sunset, a drop dead date. So all these are technical, hyper-technical points, needs lots of attention there. But you must be mindful that if you don't think through these risks, you will end up really severely getting your fingers burnt.
Yeah, so thanks for that, Prasenjit. So for me, I think the most important issues are, and I'll be brief because I think we're running out of time, is disclosure, transparency, and processes. If you are inviting international companies, people with governance to come in and actually have a stake or try and control your company, I think there should be an amount of disclosure and transparency that with which you need to greet that investor and disclose in full what is going on with the company, what the troubles are, and have processes in place that does not result in that guy losing value. Or if there is any such lapse, then point it out at that time so that he can take an educated risk and it doesn't, Ashish doesn't end up having to go to court and extracting value for you. That is one. And second, I would say is my colleague Natasha spoke about sanctions reps and some of them being mindless. But see, there is some method in this madness. For instance, a sanctions rep, a OFAC rep, for instance, the only knowledge qualifier that comes in is for employees and for agents. Now in India, each time I've negotiated those sanctions reps, they've come and told me, no, the person in control of the company also needs a knowledge qualifier. How does that work? I mean, you've been running the show. You need to know anything about it. You can't hide behind a knowledge qualifier, for instance. So these sanctions reps to me are extremely important. And if we are to actually move to the next stage, 10 trillion, some people say. So if we are to move to that stage, we need to have these processes in place that will weed out these issues and lead to a transparent way of doing business.
Natasha and we will have a tough time negotiating against you. He's not even willing to give a knowledge qualifier. Can you believe that?
Well, okay, I wanted to thank the panel. This has been, at least for me, a very illuminating discussion, and it's good to see the contrast of ideas, based on not only practicing lawyers, but, in-house counsel and how they view M&A transactions in India, as well as those that, are being dealt with overseas. So I wanted to just thank the panel for their time today, and I want to thank, more importantly, the audience. Thank you for listening to us. I'm sorry we haven't been able to get to questions because time has been quite scarce today. But feel free to ask us after this session or during the course of the conference. We'd be more than happy to try and chime in and give you our thoughts about issues that you might want to just discuss. So you feel free to reach out to any of us after this session, and we'll be more than happy to talk. Thank you.